of the CPC lays down that the court shall have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred. A suit of a civil nature is a suit the object of which is the enforcement of a civil right or civil obligation. That is, the right or obligation of a citizen, rights which do not inherit in a person, a citizen of a state, but exist only by virtue of his being a member of state or religious community, and not civil rights. It follows that a suit is of civil nature if the principal question in the suit relates to civil right or a right to property or to a office. It is the subject matter of the suit which determines whether or not a suit is one of a civil nature. The explanation appended to section 9 shows that if the principal or the only question in the suit relates to a caste question or religious site or ceremonies, the suit is not of a civil nature, since it does not deal with the rights of person but with the matters purely social. But when a caste question or a question relating to religious rites or ceremonies is not the principal but only a subsidiary question in the suit, then the principal suit is of a civil nature. Example, it relates to a right to property or to a office or to any civil right, and such question of civil nature cannot be decided without deciding the caste question or the question relating to religious rites or ceremonies. The court has the power to determine the caste question or the question relating to religious rites or ceremonies to enable it to decide the principal question. So, when a case can be termed as civil nature, these are the essential conditions which should be kept in mind. By CPC Amendment Act 104 of 1976, the number of the original explanation under section 9 has been numbered as explanation 1, explanation 2, and explanation 2 has been newly inserted, which runs as following. For the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1 or whether or not such office is attached to a particular place. Execution of civil court's jurisdiction. Civil courts exercise general jurisdiction of a civil court as conferred by section 9. It is well established that the exclusion of such jurisdiction is not to be readily inferred. Hi, welcome. For the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1 or whether or not such office is attached to a particular office is attached to a particular place. Exclusion of civil court's jurisdiction. Civil court exercise general jurisdiction of civil nature as conferred by section 9, and it is well established that the exclusion of such jurisdiction is not to be readily inferred. The question of exclusion of civil court's jurisdiction has been considered by Supreme Court in many cases. In case of Dhulabhar versus State of Madhya Pradesh, AIR 1969 SC 78 has laid down the principle for considering the exclusion of civil court's jurisdiction, which are as under. Number 1, when the statute give a finality to the order of the special tribunal, the civil court's jurisdiction must be held to be excluded if there is adequate remedy to do what the civil court which normally do in a suit. Such a provision, however, does not exclude those cases where the provision to a particular act has been complied with or statutory tribunal has not acted in conformity with the fundamental principle of judicial procedure. The decision given in the recent case of PK Development Authority versus R. Bhadra EII 2002 OD 207 is quite pertinent in this regard. The court found that the person aggrieved by an order of demolition passed under Section 91 of the Odisha Development Authority Act 1982 has adequate and efficacious remedy in the shape of appeal before the state government. The legislature, in his wisdom, made that decision under the Act conclusive and final with a further stipulation that it was not for the High Court to question that wisdom. The High Court observed that thus the conclusion is irresistible that without exhausting the remedies under the said Act, a person cannot knock at the door of a civil court, that the civil court has no jurisdiction to entertain such a suit. Number two, when there is an express bar of the jurisdiction of the court, an examination of the scheme of the particular act to find the adequacy or sufficiency or the remedies provided may be relevant, and it is not decisive to sustain the jurisdiction of the civil court. Where there is no express exclusion, the examination of the remedies and scheme of the particular act to find out the intendment becomes necessary, and the result of the inquiry may be decisive. In the latter case, it is necessary to see if the statute create a special right or liability, and the provisions for determination of the right or liability, and further lays down that all question about the said right and liability shall be determined by tribunals so constituted, and whether remedies associated with actions in civil court are prescribed by the said statute or not. Number 3. Challenge to the provision of the particular act as ultra-violate cannot be brought before tribunal constituted under that act. Even the High Court cannot go into question on a revision or reference from the decision of the tribunal. When a provision is already declared unconstitutional or the constitutionality of any provision is to be challenged, a suit is open. A writ of certiorari may include a direction for refund if the claim is within the time prescribed by the Limitation Act, but it is not a compulsory remedy to replace a suit. Number 5. Where the particular act contains no machinery for refund of the tax collected in excess of constitutional limits or illegally collected a suit lies. Number 6. Question of the correctness of the assessment apart from its constitutionality are for the decision of the authorities, and a civil suit does not lie if the orders of the authorities are declared to be final and there is an express prohibition in the particular act. In either case, the scheme of the particular act must be examined because it is if it is a relevant inquiry. 7. An exclusion of the jurisdiction of the civil court is not readily be inferred unless the condition above set down apply. In this connection, see also Raja Ram Kumar Bhargava versus Union of India AR 1988 SC 752, the state of Madhya Pradesh versus Gyasi Ram AR 1993 MP 155. Number B. Number B का 1. No, the civil court cannot question the jurisdiction of a criminal court in passing an order of attachment. The civil court can inquire into the plaintiff's title and then declare as to who the rightful owner is and who is thus entitled to the property. Order under section 146 attaching the property till a declaration by the civil court is within the jurisdiction of a criminal court. Number 2. No, if the voluntary offering are made to an usurper in his personal capacity as opposed to the offering made to him with regard to an office, the main test is whether it is a right in property or not. An injunction or declaration for restraining another person from interfering with such right can no doubt lie. But when such duty is attached to such a voluntary offering, no suit lies. Number three, yes, it if it has violated the recognized rules or procedure of the clubs or those of natural justice, a court of law will not interfere with the action of the club on flimsy and insufficient grounds, as it is also an autonomous body. Such a suit is an interference with a legal right of a person. Number 4, yes, as it is an invasion of civil right, the right of burial of a certain person or of a certain class of person is a civil right relating to property.